Welcome to another edition of Asia Sensemaker, a space for informal yet thoughtful, thought-provoking conversations with leading voices across law, policy, and society. Today, we are joined by Prashant Diti. He studied law at the National School of India University and Stanford Law School. He has worked in law firms as well as in academia in India and Singapore. He is also the co-author of Create, Copy, Disrupt, India's Intellectual Property Dilemmas and the Truth Pill, The Myth of Drug Regulation in India. We also have with us Ms. Chitrashi Jain. She studied law at the National Academy for Legal Studies and Research and completed her postgraduate studies in political science and law and governance at University of Delhi and Jawaharlal Nehru University. She has worked as a researcher in civil society organizations and think tank on issues related to access to justice, functioning of public institutions, and judicial reforms. A warm welcome to both of you. Our conversation today is centered around their co authored book, Parik pe Justice Reforms for India's District Courts. The book offers a deep dive into the dysfunction that has long plagued the district
Thank
judiciary.
you for having us.
The only layer of courts that truly spans every district of India. Of the three tiers of the Indian justice system, these courts shoulder the heaviest caseload and serve as the first point of contact for most Indians in search of justice. In many ways, they are the face of the judiciary for ordinary citizens. This book is essential reading not only for those curious about the justice system, and how it actually works or fails to work, but also for anyone who cares about the rule of law. The book is an honest attempt on judicial reforms so that justice in India does not remain trapped in the endless queue of adjournments and pending dates. With that, I invite our moderator for the session, Professor Amok Dev Rai, Research Director at the Advanced Study Institute of Asia, to open today's discussion. Over to you, sir.
Thank you, Shivani. And I welcome both the authors of this book. Sorry, the lovely cover of your book is missing. In all my travels, etc., I seem to have misplaced it somewhere. But it is a fascinating book. And thank you very much for writing it because I'm an economist and we don't often get to see the underbelly of the Indian justice system, especially in the courts. Before we really get on to the book, there's a question that's been haunting me ever since I read your book. And I've read it twice now. I don't think you can see some of the dog-eared pages had in the book.
Thank you.
I see a very interesting shift in how the justice system thinks about justice, evidence, and also the need for running democracy. And it is very interesting because there is a huge gap between how the learned judges of the High Court and the Supreme Court, when they talk about justice at the top tier, versus when they look at the cases that are coming to the district courts. Why is it that the Constituent Assembly, the makers of the Constitution, and then essentially the people who were deciding about how the Constitution is going to be run, the judges, they did not really pay any attention to the lower courts. I mean, it would be that from the first law commission that you speak about the first law commission, and then you jump into the reports coming out of the law commissions in 1980s, etc. And we see that the lower courts are just often seen as instruments of um, rough justice, and they're not really that important. So tell me a little bit about this mental gap, or rather the intention action gap.
Yeah. First of all, thank you for having us and for having read our book twice. Uh, so let me just start off, and I think Chitrashi can jump in whenever she feels like. I think you ask a pertinent question, because the first draft of the Constitution that was actually submitted to the Constituent Assembly by the drafting committee did not mention anything about the district courts. It was after some judges raised issues that it came up, that they included a chapter on district courts and the subordinate judiciary specifically in the Constitution. And I think one of the reasons for this, the stepmotherly treatment with the district courts, some of it just goes back to our colonial history, where the high courts were always the most powerful courts, because they were staffed primarily by, white Europeans coming in from Europe. Indians got onto the high courts a little bit later. So they were always structured as the most powerful layer of the judiciary. So even after independence, one of the first things that the political class did is that they ensured that the power to decide election disputes shifted from the district courts to the high courts. I mean, that was an early sign in the 60s itself that that they knew that things weren't right in the district courts, and they wanted to preserve their electoral battles for the high courts. A lot of it, I think, has just got to do with colonial legacy. That is, high courts were seen as these British institutions, powerful, controlled by Europeans, and the district courts were always staffed by uh, mostly Indians. There were some Indian civil service officers who held the position of district judge or sessions judge, and they always weren't given enough power. So, for example, till date, a district court judge cannot hold the government or any party in contempt of court, right? He can sentence a person to death, but he can't hold a person in contempt of court. Similarly, something as simple as a habeas corpus petition, which is considered to be one of the most fundamental remedies, only a high court can issue a habeas corpus petition. A district court cannot. So the district courts just weren't given enough power, and because of which they were never perceived to be that important. So it's like a chicken and egg situation, right? The moment you give them more power, they're considered to be more important because they can hold government accountable. But until such time, they are going to always be considered, second tier courts. Chitrakshi, you want to add something to that?
Yeah, I mean, the omission was also quite glaring, that the fact that the first draft did not really have a provision on district courts, because the Government of India Act 1935 did in fact have provisions relating to judicial officers. So it was particularly glaring that they did not think about it. And secondly, in terms of the constitutional protections that are given to the security of tenure of the high court judges and supreme court judges vis-a-vis the district judges, that gap becomes even more apparent, where we know that their security of tenure is treated at a different level, and the district judges and the subordinate judiciary does not have the same protections constitutionally.
May I just infer from this conversation a little bit? And because you do refer to it towards the end. I mean, when the idea for Gram Nyayalaya gets mooted by the second UPA government, if I'm not wrong, the first UPA government, but then it comes up as a policy proposal in the second UPA government. Do you think that the makers of our constitution and the Constituent Assembly, they had some sort of ideas about how, I'm getting this idea from Hind Swaraj, the 1909 pamphlet by uh, Gandhi, where he specifically says that lawyers are the bane of society. So if lawyers are the bane of society, then lower courts, let's get rid of them. Do you think there was a certain sense of idealism in the makers of the the makers of the constitution, that perhaps we won't really need courts at all? Were they still seen as an extension of the colonial Raj? Because, the lower courts, they are the first point of contact. This is the point you make throughout the book. They were the first point of contact to for a citizen to seek any redressal against injustice. But in a country that prides itself on its constitution, prides itself on its legal apparatuses available to its citizen, we see that the first point of contact is very shallow and can't really do much, and is under the strict control of the government. Was there a little bit of let's be optimistic about not needing recourse to justice?
I mean, I wouldn't say that it's under the strict control of government. Chitrakshi, you wanted to say something?
No, you carry on, and after that, I'll.
Yeah, so I
following.
mean, they are not under the strict control of the government. In fact, they are pretty well insulated from the government. They are under the very tight control of the high courts. So those are two different issues, right? Because the judiciary has interpreted the constitution in a way to ensure that the state government has no say really in the promotions, transfers, or removal of the district court judges. So to that extent, they are very well insulated from the the state governments. The problem is when the high courts wield that same power, they are not wielding it in a transparent, accountable manner. They're very arbitrary when they deal with that power. But to get back to your question of about Gandhi and wanting to do away with lawyers, yes, I mean this contempt for lawyers is quite strong. Even in the 80s, we have seen a lot of laws being drafted, not just in the 80s, in the 50s. For example, in labor courts, you don't need a lawyer to represent you.
Yeah.
Technically, even in the consumer courts, you don't need a lawyer to represent you. So they started fashioning these new kind of forums where you don't need a lawyer because the lawyer was seen as the problem. But
Hmm.
even with the Gram Nyayalayas, it is actually a British invention. So back in the day, even during pre-independence, you used to have something called village courts, and this is prevalent not only in India. It's a legacy of colonialism because even the US has it. Because at that, basically the issue was providing justice is expensive. We want a cheap way to provide it for the villagers because it's tougher to get judges and lawyers, qualified judges and lawyers, etc., to go over there. But if you study how the village courts experiment has played out, because a lot of states repealed this in the 70s, they had Village Courts Act. They repealed it because studies basically showed that these courts did not function very well. Some states in India still have it, which is Bihar has one. Bihar still has. They enacted a law, I think, in sometime in the 2000s. In the 90s, it was constitutionally challenged. Again, in the 2000s, they enacted a law. And if you read the evaluation reports of that law, they say, it's working very well, but we need people with more legal knowledge to be helping out in this. And who are people with more legal knowledge? They're lawyers, right? So at the end of the day, you need to concede that some aspects of law are going to be a bit technical and not just technical. Like a legal education does teach you how to think in a certain structured manner. And there are a lot of times when clients will come and lawyers will give them solutions which they have not even thought of. So this idea of trying to, shoot the middleman and get him out of the way and presuming that the entire system will fix itself is perhaps not going to work. I mean, that's separate from the fact that we think that common people do have a role to play in the justice system, like a jury. Again, over here, you had Gandhi say that, juries are crap. We should go back to panchayats. The only difference between a jury and a panchayat is in a jury, you at least have a trained judge who's ensuring that the rules of fair play are followed. In a panchayat, you don't even have that. So there is some room for participation of common people, etc. But the rules of fair play, the rules of procedure, evidence, wherein we think that the process is as important as the outcome. In that scenario, you need a trained legal professional to be interfering somewhere. And that seems to be the major point of difference in a lot of the left critique of the legal system. The lawyer is seen as the problem. They just want to get away with the lawyer, and they think something pure is going to emerge out of this, which is not the case in my opinion. Chitrashi,
Yeah.
anything you want to add?
Yeah, I think there are two themes here. The one is, as you rightly identified, was the revolt against institutions which were thought to be more colonial, and this is a running theme in law reform where people have tried to mold it into ideas of indigeneity, and somehow panchayats are seen as institutions which are more indigenous. And the other idea is informalism, where you want to argue that procedure is what keeps the common person away from getting justice. But even earlier ethnographic work on Indian courts has showed that as soon as these courts were introduced, people were flooding to courts to file revenue cases, etc., land litigation. So it wasn't really that this procedure was seen as an impediment by the natives, so to say. In fact, they really embraced courts. The filings in courts vis-a-vis these Nyaya Panchayats or village courts, whatever iteration of it has been, will clearly demonstrate that people, in fact, have more faith in the formal procedural institutions than these so-called informal institutions that the government has been trying to experiment with, and even the Britishers did for a while. Because I think arbitration and panchayats are seen to be something more indigenous and cultural to the country, but I don't think that's how institutions work. It's not it's colonialism is not really constructed by the colonizer. I mean, it's always an interaction between the locals and the institutions that are imposed on them.
This is a very interesting sort of, both of you brought out this interesting perspective, and that kind of makes me shift now to the contours of the book. Your first chapter, Fearful Judges, I think kind of sets the tone for the rest of the book. Before I jump into a specific question, could you also speak to any of the judges you have written about, any of the magistrates you have written about, or was it just based on records that you could find? Because I presume finding records is, as you write in the book, time in and time out, is one of the hardest things that one could look at.
No, we didn't speak to any of these judges because, one of the problems with doing this research, apart from, difficulty of finding records, is finding judges who are willing to speak to you, even if it's off the record. Because we've done research earlier, like in 2019, we were doing some work on judicial training of judges. And we tried reaching out to these young judges who had just joined the judicial service because they were the ones who had gone through training. And more than once, when we were speaking to them on the phone, they were so afraid to speak to us. It was like, nahi sir, district judge sir se पूछना पड़ेगा, permission लेना पड़ेगा. And these are people who can, deprive you of your liberty for years together. And they're doing so actively, deciding your cases regarding citizens' liberty in court. So, trying to do these kind of interviews with them, we didn't think it was going to pan out because they're so cagey about talking to people. So we had to base our stuff mainly on, these records. But after the people were far more forthcoming in talking to us, even people in the including judges, and they basically confirmed a lot of what we have said. And in fact, there's also been some judgments recently, including from the Madhya Pradesh High Court, this Justice Atul Sridharan, who the government is again transferring to Chhattisgarh, where he's said almost exactly what we have written in the book, saying that, these district court judges have lost their vertebra. They become spineless because of the way disciplinary proceedings are, work against them, and which is why they're not granting bail. He identifies that as one of the reasons. In fact, he uses far harsher language, saying that, there's like a Varna system in the judiciary. High court judges are the Savarnas, and the district court judges are like the Shudras. So, so despite not having interviewed people, I think we are pretty much on the mark.
Yeah. No, that would be my surmise as well. But the question that comes then to the fore is that you have a landscape where people are often, you refer to New York Times, you refer to various other stories. In the reviews that have been published, be it the Business Standard or Scroll or your interview with News Laundry, what keeps on coming up is that, we hear about the fragmented justice system, which is also my opinion, by the way, that the problem lies in High Court and the Supreme Court. But most of the cases that are tied, they're tied, and you talk about the revolving docket, you talk about the fact that if a judge were to give a judgment which favors a party over the government, they could be tried. Because this is a very, this looks like a very perspicacious way, a very conspiratorial way of delivering justice to the people. So what exactly is the change today from 1945 India and 2025 India, when the justice system itself, the first point of contact for a citizen, uh, rests on the fact that if the judge were to give an order, it could be challenged and they could be, turned away. Why should then we, the citizen, have any trust on our justice delivery mechanism?
Yeah, Chitrashi, do you want to answer that first?
I mean, it could be that the pendency is keeping you away from the system, but I don't think. Of course, there is a general crisis of legitimacy in terms of that people do perceive the district judiciary to either be corrupt or inefficient or incompetent, and they perhaps think that the higher courts are more competent to deliver justice. But in terms of, I do not think, even in terms of a need, justice is something that you will either involuntarily or willingly end up interacting with. So, of course, the public trust in the system may be low, but it is one of those essential institutions that you sort of cannot. Of course, in crimes, you have no option. But even with civil litigation, apart from the fact that the pendency might deter you, and this, the conversation around the inefficiency of the justice system might want you less willing to probably file a litigation. But it does seem that, in terms of filings, people do interact with the system enough.
Yeah, and that was my point. If I might just add a little bit, because I want to understand this a bit deeper. If one were to look at the acquisition of land, right? I have been trying to track what are the most number of cases that are being filed in this particular space. So acquisition of land comes to the fore. National Highway Authority of India, they're buying land all over the place to make highways. There are some people who are willing to give it to the government for the right price. There are people who are not willing to give it for whatever reason. Now, these people go and file a case, right? And you actually refer to one of the judges who was dismissed, and then her case went all the way to the Supreme Court. She was a judge in Uttar Pradesh, I think, Ghaziabad. And then she wanted to give more compensation than what the government wanted to give at that point of time. Now, my question is that inefficiency, incompetence, all of these are different things. And we will get to incompetency because you make a very interesting point about competency not being the yardstick of how judges ought to be looked at. But just the facts. We are supposed to be a system where the powers are divided and one branch cannot influence the other branch. But in this, what appears to happen is that the government can make a complaint formally, informally
No,
through
but
the
let me
government
correct you
cannot.
that over here the government didn't complain. The case went on appeal to the Allahabad High Court, and the judges hearing the case decided that something is fishy and ordered a inquiry. So
right, and this is my point that the trust that you have to build in. If you want to get rid of, say, the pendency, then you have to build trust in the first layer of justice delivery mechanism. That has to be developed, but
No, I just wanted to interrupt and say that trust that the public has in the system is one thing. I think what we were talking about, particularly in this chapter, is the confidence that judges themselves have in their own decision making, which currently is under threat because of these inquiries, these disciplinary inquiries, which also do not give them immunity for on the content of their judgments. That is a worrying aspect, that the judges themselves are not secure to write judgments freely, given the fact that this Sadhna Chaudhary wanted to give a certain quantum of compensation, and that could be used as a trigger for a disciplinary inquiry that compromised her career progression, and she litigated for so long. This is very worrisome because the effect that it has, I mean, this is not information that is easily available to the public or the public is interested in, but her peers and her colleagues do know what is happening to her, and we are using her as an example, but this information is in fact more relevant to her peers and her colleagues, and the message that is sent to them is what we should really worry about.
But if I can also add, on your point on why should citizens continue to trust a system which appears to be, so compromised internally. I mean, for a lot, like Chitrashi said, for a lot of issues like bail, etc., they have no choice. You need to get out of jail, so you have to interact, and which is why our hypothesis is that the High Courts and Supreme Court are flooded with bail petitions because it's getting impossible to get bail before the district judiciary, specifically because a lot of judges are being punished in disciplinary inquiries for granting bail. We've never seen a case where a judge has been punished for denying bail. Uh, but in other respects, we see uh, citizens and lawyers both trying to avoid courts as much as possible. So you do have a point over there. For example, a lot of civil disputes, a lot of lawyers will say, let's go file a complaint first with the police because it's easier to manage the inspector. He'll get things done faster than the court. So that's one form of, the judiciary losing its legitimacy. There are other forms too where the widespread support that we see for, encounter killings where cops are killing people in cold blood, this bulldozer injustice, the the degree of public support that we are seeing for these is chilling. Like when those four men were shot dead in Hyderabad, in 2019 after that the gang rape of that young lady doctor. That was shocking, right? Because it was also the first one of these first encounters in the social media age. This wasn't the scenario even 20 years ago in India when Ansar Plaza killings happened and all. There was a genuine outrage. So now we have reached that crisis point where this is how you're going to see signs of legitimacy of the judiciary, wilting away. You're not going to see, it's not going to be something dramatic that happens overnight where people go and raise down the judiciary. It may happen, it's happening in countries, like in Bangladesh, this time that revolution that happened last year, they made the Chief Justice resign. I think must be one of the first instances. In Mexico, we are seeing, such frustration with the judiciary that they've replaced the entire judicial system with a system of elected judges. So these kind of signals are what we need to be looking out for. And in India, those signals they are blaring in our face. We just aren't, at least the chattering classes are not sitting up and realizing that this is now a system that has reached a crisis point. And the reason they've not realized it because we have been saying the justice system is in a crisis literally for the last 100 years. 1925, there was the Rankin Committee report on civil justice basically said, oh my God, nothing is working, blah, 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 blah. But now I think is when we should really start worrying. The kind of support that we are seeing for illegitimate forms of violence by the state, that's when we should really start worrying.
And this is the thing that I was talking about. The point being that the state governments, they are powerful today. I mean, whoever is forming our government today, they're coming in with a clean majority. For now, the era that you needed a coalition partner, so you would try to make sense of try to get your uh, different societal integrations working properly. But look at the case of Uttar Pradesh. You refer to Uttar Pradesh, Madhya Pradesh, Karnataka, Gujarat quite a lot in the book. In fact, Madhya Pradesh seems to be a state with a lot of data that you've been able to find. It was fascinating to read because the what you are writing in the book presents a very pejorative picture of justice delivery, but also the fact that societal trends are shaping up judiciary and not the other way around. And I think the fact that the clamor is now rising to the High Court and the Supreme Court just makes the point that you are underlining time and time out. And that brings me to a very interesting, but also a very disturbing question. Uh, the government of India for the last 11 years has been trying to track all kinds of indices, be it the innovation index that I think you've written about in Create, Copy, Disrupt, and then you've also written about it in other spaces. Uh, Almost all of these ease of doing business and all of these indexes that we try and track and that our newspapers write about whether we are performing well or we are not performing well, almost all of them have a huge component of justice delivery mechanism. Contract law, for example. if your contract is not adhered to, then you can't really be doing well in the ease of doing business. But from reading your book, it appears that the union government and the state governments are not taking any cognizance of how the lower courts ought to be run. Is it that the high courts have such an iron grip on how a district court ought to be run that the governments have given it up as a lost cause?
No, because I think, since the 90s, the Supreme Court has been driving the narrative on judicial reform. When they did through a series of PILs called these All India Judges cases, and the Supreme Court has very successfully framed the entire issue as one of lack of resources. That is, you give us more judges, give us more money, and things will get better. They've relied on absolutely absurd indicators. For example, this formula of we need these many judges per, I think it's 50 judges per million of population. That is a formula that has no basis in any kind of academic work. It was a formula, we've written about it. It was invented in a specific context. It has no relevance to actually calculating the number of judges that are required by the country. So once they have framed this issue in this manner, of just shortage of judges and shortage of resources, we've had a lot of economists amplifying this in the public policy debate. No offense to you as an economist, but without
I'm a health
looking
economist.
Sorry, you're a health economist, okay?
Health economist.
So that's the problem, right? The issue has always been framed like this, and so the government, to its credit, has actually responded by saying, okay, we will increase the number of judges, we will increase judicial capacity, we will increase judicial funding, which they have. Since the UPA years, the union government has been pumping in money for infrastructure, both physical and digital. We've not had this conversation on what exactly is the judiciary, where is the judiciary exactly, dysfunctional within itself. And part of that failure is definitely legal academia has just not been looking at the issue of district judiciary. Because there is, even in legal academia, there is like a caste hierarchy that is there, where there's some subjects that are considered to be more glamorous and prestigious, and the district courts are not one of those subjects. I mean, which is why you won't find anything else written on the district courts, apart from there's one academic in Jindal Law School, Professor Shivraj Kuchinavar, who's done some good work on this area. But just one academic studying this is absurd, given the scale of the problem. So I think it's a big problem is just the framing of the issue has not been done accurately, and the government at the end of the day is not going to sit and do this kind of academic work where they're going to try and brainstorm what exactly is going wrong. They will take their cues from academics who have kind of put forth. And if you open any book written by any of the these economists write these popular books these days, right? Popular non-fiction, where they identify different problems. They all identify lack of judges as the primary problem, because they've taken their cue from some tearful conference that a chief justice of the country has given at some point, right? It's not based on real academic work. So it's a failing, definitely, I think, of the academic community also. It's up to us to be framing problems and putting them out there in an accurate manner. Chitrashi, anything you want to add?
Yeah, and also governments also sort of distance themselves from these issues because the way high courts and supreme courts want to exercise control over these courts. It seems like it's quite clear that no decision about the resources of these courts or even the service conditions of judges can be taken without the consent of the high court. So the government, as because it has been blamed for resources, it has done what it can to give it more money in terms of infrastructure, etc. But it does maintain like a one arm's distance because the Supreme Court is so aggressively pushing the reform agenda at the top.
So now that we are talking about the Supreme Court and the reform agenda, and Prashant and both of you have brought it up, but Prashant actually talked about that, the All India Judicial Association. So the first PIL while listening to the first case that was filed in front of it, they let go of the experience question. You write about it when you write about too young to judge, right? 8 years later, the Supreme Court of India, a different bench, does a U-turn and says, oh, you know what? They actually don't need any experience to be judges, because the idea being that we have to catch them young. Because if you're not able to catch them young, then they're apparently going to get into legal profession and they're going to make so much money that perhaps they won't want to become judges again. So tell me a little bit about, this yo-yoing that you have pointed. I mean, there are far too many instances. I'm just giving you one. You've categorically said and tabulated how the judiciary, the senior judiciary and the high courts, the Supreme Court, they frame a problem, they diagnose the problem, and then they start the wrongest treatment that they can for it, right? Where does this come from? And why does this happen? And why is it not challenged anywhere?
Yeah, I mean, see, so this is a product of the Supreme Court's God complex that has emerged in the PIL era, right? Where they'll appoint a senior advocate from the bar as an amicus, and then they just presume that they have all the answers. I mean, the arrogance is just amazing. They think that one amicus and finish. Now we have all the solutions. Even this issue of the qualification requirement, right, for judges, that is, should they have any practice at the bar, they've again reversed themselves a few months ago. So the 3-year requirement now has been reinstituted by a Supreme Court judgment 23 years after it was first abolished, because the Supreme Court's internal think tank, this called the National Court Management Systems, they finally asked high courts and I think state governments on, what is your view on this? Majority of the high courts and the Bar Council of India came back saying that this has been a complete disaster, right? And this is the right way to do policy making. You have to consult people, get their views on board. And the courtroom is the worst place to conduct this. This internal think tank that the Supreme Court now has, they don't work within the courtroom. They work on a more consultative manner. And which is why you've had a series of these bad decisions, because you've got these judges who have, they've been on the bench now for at least 15 years on most cases. They're used to people deferring to them all the time. And they just presume that they have all the answers. I mean, some of it is like just uncle mentality, where at a certain point, after 50, if you're an upper caste male in India, you think you have all the solutions to the problems of this country. And the other problem is that on the Supreme Court, this problem magnifies 1,000 times. You're just convinced that we'll take care of things like this. So there's no humility within the legal profession, and it's unfortunately, it's true that the legal profession in India, even in the Supreme Court, is quite mediocre, both at the bar and the bench. So it's no surprise that they're constantly coming out with, these bad solutions which cause damage, and then they have to fix them. And repairing some of the stuff is very, very difficult, right? So the pushback is not coming because who can push back to the Supreme Court? The lawyers will almost never do it. The Supreme Court bar is the cause of many problems. Like the collegium and all is what the Supreme Court bar has backed. They asked the Supreme Court judges to create it. The government is quite hands-off on this because they are worried that they're going to be bogged down, on allegations of, impinging judicial independence. The last set of people are actually academics in these national law universities who should be doing this. But then you've got Supreme Court judges, High Court judges sitting on the governing councils of all these national law universities. And with private law colleges, it's not going to be any different, because private law universities also depend on these judges for some kind of patronage. You have to come for some event, this, that. So they can be even more risk averse. So we've got the situation where we have like this imperial judiciary which is accountable to nobody and has appropriated for itself the powers of the purse and powers of policy, which is why we're stuck in such a bad situation right now. Chitrashi, do you want to add to my rant?
Yeah. So the other implications of the centralization, apart from the fact that the Supreme Court is just not a suitable site to make policy, is also that then we lose the benefits of any competitive best practices that might emerge from individual states. So what we have seen in terms of judicial statistics, even when it comes to calculating the right number of judges, because both of these policy agendas and what has to be measured, captured, published have been centralized by the Supreme Court. The outcome is that we don't know what it would have been had the High Courts taken that initiative. And maybe some high courts must have done, even today, the high courts that are being slightly more autonomous with these things are performing better than others. And given that we want to centralize the publication and collection of statistics, what we see, like the mistakes that Supreme Court makes are then replicated everywhere. So we don't even learn from what could have happened if we had a more
Right.
competitive federalism going. Yeah.
Yeah, federalism, I think, is like baby out with the bathwater at this point of time, unfortunately. But that brings me to another very interesting thing that you guys talk about in the book. I was fascinated, or rather, it fascinated me to find out that we are the greatest statistical state at this point of time, behind China. But when it comes to the National Judicial Data Grid, uh, statistics seems to be doing its own thing there. You know, it seems to have given up the sample space and everything else quite a miss. 777 cases apparently being tried or being disposed of by that's the median number you guys quote about, where to be not be inadequate, the number is a factor of 6 less than what you guys quote in the book. So the National Judicial Data Grid, uh, a lot of money has been spent on it. The idea is that it's an accumulation of facts and statistics which looks at judicial delivery in the right light, evidentiary policy making. But this experiment seems to have kind of hit a wall, if I may. Can you tell me a little bit more about how A, how can it be salvaged, but also B, what are the challenges that one must face, uh, say in Delhi versus, say, Bihar? You compare Delhi and Bihar in the sense of that population is not the best way of trying to find out how many judges you ought to have, but also the complexity of cases, right? So, how can the same yardstick be used for measuring a judge, a probationary judge, or even a non probationary judge who is working in Bihar, where the kind of complaints, the kind of uh, legal problems that they have to deal with would be very different from, say, what you're dealing with in Maharashtra, Delhi, Andhra Pradesh, Karnataka. So, shed a little bit light about the idea behind this National Judicial Data Grid, and then what we are looking at now.
Yeah, I mean, so the National Judicial Data Grid was supposed to basically fix the problem with a lack of statistics. Basically, when we were ruled by the British, we had a pretty good system of judicial statistics. The High Courts used to release annual reports on civil criminal justice with statistics that we can only dream of today. It's easier to research 19th century colonial high courts than it is to research 21st century high courts, because the data that they have is just great, which is what like Tirthankar Rao and Anand Swami, they've written this book on law economics uh, in India, basically in the colonial era, and they've had access to great data because the British maintained that data. So the National Judicial Data Grid was supposed to fix the problem, but it has turned out to be a complete disaster. And the project is a good example of why you should not vest these powers with the Supreme Court, because the Supreme Court was given control of the entire e-committee project, the e-courts project, which they run through an e-committee. We also argue in the book somewhere it's not constitutional, because this is an issue regarding judicial administration, which is technically supposed to fall under the purview of the high courts. Because if it was decentralized, it would have probably been done much better. Because the registries of the high courts have an incentive to ensure the project was designed properly, because they are the ones otherwise who have to do this work of collecting statistics. They don't release it, they still collect some statistics, they don't publish it because they need to show it to the high court judges. So the way it's designed is just disastrous. Like our main suspicion is that we are significantly overcounting cases, because on the criminal side, we are basically counting every motion in a single case as a separate case. So for example, if there is one FIR filed, criminal investigation has started, and there are 5 people arrested, all 5 of them move a bail application, which is rejected once. The system counts each one of those bail applications as a separate case. So they file bail application a second time, they're granted. System then counts 10 cases. This is just not the right way to count cases. I mean, you don't need you to be a lawyer to know that. So this inflation is happening, which is one of the reasons that we don't have faith in what these statistics are presenting. And the fact that we don't have proper statistics has been known now for a long time. In 2003, Fali Nariman, 2003 or 4, Fali Nariman, when he was a nominated MP to the Rajya Sabha, had introduced a bill specifically for collection of judicial statistics. And today, because of technology, it's much easier to do it. The fact that we are not doing it, the courts are not interested, tells us a lot about their attitude towards transparency and judicial administration. Regarding your second point on this, the norms issue, so every state has its own set of norms to evaluate judges. On how are they featuring complexity, etc.? That's a good question, because we don't think that they are doing a very good job of it now. And that, it feeds into a hypothesis, and it's kind of confirmed in some of our conversations we've had since the book is released with judges, that they are, because the norms, this unit system, which gives them certain units for each judicial task, plus the requirement that they dispose certain number of cases, because it doesn't feature complexity, the incentive then for a judge is, I will just dispose the easiest cases first, because I need to meet that unit system. I need in order to maintain my ratings. So he will not tackle the tough cases at the beginning. So that's why the hardest cases fall back in the queue. And this is a problem that has been known for 100 years. The Rankin Committee and all have pointed this out. No one is looking at this issue. So solving this is going to take a lot of effort, because we are not even close to talking about it enough. Chitrashi, would you like to add something, please?
Yeah, not only does it not measure the complexity of cases, it can also be used as a trigger to further sort of threaten these judges, because they are subjected to these reviews, and if they don't meet the units, and when they're evaluated in this ACR, they do not really meet the units, that can be used as a trigger to start either at a later stage. So there are certain categories of judges who can be compulsorily retired when they reach certain milestone ages. So if they, at some point, if they've had adverse entries in their ACRs, or their performance has not been good, that can be used as a trigger to compulsorily retire them. And the judges who are in service, often they are staffed in districts which don't get that much litigation. And so if they again, because these units are just standard units that they have to meet, sometimes they are also unfairly given a poorer rating than they deserve.
This is very interesting, because the bureaucracy, the place where ACR has originated from, they are trying to move away from ACR stuff. The government has this entire scheme called Project Karm Yogi or Mission Karm Yogi, where they are trying to make it much more evaluative, much more hands-on. But that doesn't seem to have kind of moved all the way to the courts. So that's my reading. I was trying to find out information, but the information is really opaque about how judges are trained. At least bureaucrats can take mid-career breaks. And it fascinated me. I actually tried finding out, can a district judge go on a career break and, go and study in Stanford Law School or Harvard Law School? Is that possible? Does the government fund it at all?
We
I
don't
don't think so. I
know.
don't think it exists. As far as I
Because
know,
I
it's
got
not good.
fascinated by this. I was trying to find the answer to it yesterday. And I was
Yeah.
speaking to a couple of people and they said, well, if they know some judges, then perhaps they can, but they're not really given any kind of study break.
I
As
mean,
far
they
as I know, it
do
doesn't
pursue
exist.
masters. Maybe they do it alongside their jobs because a lot
They
of
they
judges
do it
then have
alongside,
LLMs. Yeah, yeah,
But
but
I
they
don't
do
think,
it from
see,
private colleges.
but
perhaps.
state governments, do they state governments send their officers abroad on study leave? Because I
Some
think it's
state
a
governments,
central
yes.
government. Some state
No,
governments
no.
do.
Andhra Pradesh, Karnataka. You could also get it now in Gujarat. So a lot of these state governments, they do.
So it's likely that those rules will apply to these judges as well because most of their service conditions are actually they resemble the executive bureaucracy in the state, except for the fact that the decisions of whether which judge can be sent will be taken by the High Court, for example,
High Court,
and not the state
right?
government. Yeah.
Right. The fascinating thing to study. We have
Yeah.
we've hit the 51 mark. I have a lot of questions. I'm just going to ask two and then open it up for people on my team who have read this book and want to ask questions. There are quite a few questions there as well. Uh, One thing that I could not get from your book, and I thought I'm going to ask you because getting information about it, I'm pretty sure would be very hard. Tell me a little bit about affirmative action, how it has moved. I mean, you do talk about how um, more and more women joining the courts meant that the salacious gossips and rumors about who they know and what they know, et cetera, could mar their career. You have a case of a judge in Gujarat who had who was dismissed because she was a probationary judge because of some rumors that were circulating about she knew somebody, some other judge, and his wife committed suicide, and so on and so forth. But what about judges coming in from uh, backward communities? How are they treated? How is this entire thing? How is affirmative action that you see in other parts of government jobs and bureaucracy generally? Has that translated well to this?
Well, so whichever state governments, whatever system of quotas, reservation quotas they have for the bureaucracy, it generally applies even to their state judicial services. So it's not consistent across the country. So there'll be different formats. But yes, so there is at the district court levels there are quotas for scheduled caste, scheduled tribe judges at the very least. Plus, whichever states give OBC, and Karnataka has some rural area reservation, etc., etc. Now, to evaluate how it works and whether they are facing discrimination and all is a very very difficult task, and we weren't able to do it. Uh, but there, I mean, like there's one case that where we came across where a judge in Kerala was under a disciplinary inquiry, and he was challenging that. No, he had been dismissed, and he was challenging that, and the judgment begins with it's a Muslim judge who's writing it, and he starts off with saying that this candidate was recruited in a special drive for SC/ST candidates. When you start off with a judgment like that, it has no relevance whether he was recruited through a special drive or not, and you can see what is playing out after that in the judge's mind. But in conversations that we have had, again after the book published, people are a lot more candid for some reason. But they are High Court and Supreme Court, retired Supreme Court judges told us that it is a huge issue. Caste is a big issue playing out in a lot of places. It just doesn't get enough attention. And if I can give you an anecdote about 4 or 5 years ago when we were working at another think tank, we were trying to do a survey of the legal profession, and we had included one question on caste. On what is the perception of lawyers? Do they think that the caste plays a role in how judges are deciding the issue? And it was such a prickly question, and there was such a worry over contempt that we had gotten some advice, like we sought legal opinion from a judge who said that, a retired Supreme Court judge who said that no, don't ask. So I mean, you have anyway. These are problems with doing research in India, especially with the judiciary, because they have in the past, they tried to jail Madhu Trehan for a survey that she did on Delhi High Court judges. So the red lines aren't clear on how you can do surveys of some of these judges. So this kind of information you can get in empirical manner only if you do a proper survey, and I don't see that happening anytime soon. Chitrashi, anything to add to this?
Yeah, I think caste is in fact more difficult to study, but for gender, there are even Supreme Court judgments which more recently this year, I think Justice Nagaratna had reinstated 2 judicial officers from Madhya Pradesh. And that judgment, in fact, gives you a detailed view of how gender plays a role in their, in their service conditions, etc., which are not very I'm sorry for the noise. If you can hear, there's some construction going on. So, gender is in fact well documented even in Supreme Court decisions where they have looked at how that plays a role and compromises their chances in a judiciary career.
Right. Well, kind of that brings me to my last question, but not out of my free will, just because of lack of time. There are far too many other questions that I would love to have asked. But here it goes. Do you think that the mechanisms that have been put into place, I'm specifically referring to, and you have spent some time answering this earlier, the Union Carbide plea and that particular formula that Government of India got an American professor to write about how India does not have the capacity for complex judicial questions to be addressed in India. And then you have Justice Thakur crying over 70,000 judges that apparently we don't have. So this sort of shifting of the blame game always on number of judges that we don't have we actually made any empirical study as to the newer forms of tribunals that are being created? Because the idea is that a debt recovery tribunal is going to take away the pressure on the frontline justice delivery mechanism. Do you think that all of these debt recovery tribunals and other tribunals that have been created, going all the way up to the National Green Tribunal, have they been any good at effective implementation of judicial thought and judicial activism?
I mean, there are complaints all across the board against these tribunals. I mean, the Debt Recovery Tribunal was clearly a failure, right? Which is why you had to bring in the IBC, the Insolvency and Bankruptcy Code, and then create a new tribunal, the National Company Law Tribunal, to deal with this stuff. Empirically, I don't think there are any studies on evaluation, on evaluating how these tribunals work. But like, for example, we know that the Debt Recovery Tribunal Bar Association in Bombay has litigated, I think, at least once or twice. It's gone up to the Supreme Court complaining that there are just no resources provided for the tribunal. The Debt Recovery Tribunal in Bombay just doesn't have the resources to operate. That is, they haven't appointed enough judges or recovery officers. They're not appointed enough. They don't have courtrooms, etc., etc. And this is a long-running problem. Similarly, even NGT had like massive teething issues when it was initially being constituted, and it later had, more recently, it's had several problems with its functioning, where the Supreme Court keeps smacking it down for not following procedure rigorously enough. So the tribunals have been quite a mess. It's been getting a little bit academic attention recently, but not enough. And I think we also haven't developed proper frameworks to assess how tribunals are working. I mean, time cannot be the only issue, right? To decide whether a judicial body is efficient. Time should be one of the issues, but it can't be the only issue. So because the constant complaints that we receive is quality of the judges is just appalling on a lot of tribunals. And that's because of the way the tribunal system has been designed, where unlike say, High Court judges or Supreme Court judges who can retire at 62 or 65. These tribunals have been designed in such a way, they've been designed like the bureaucracy for the bureaucracy. So they offer like only terms of 5 years, which means you're not going to get the best candidates. That's a guarantee that you're not going to get the best candidate. Nobody wants, to work at a position for 5 years and then not know what he's going to do after that. So the tribunal system is a mess that requires a lot more attention than it's getting from the government or will get from the government anytime soon. Zakshi, want to add something?
Yeah, the other problem with tribunals is the access to justice, the geographical access to justice. Is that sometimes they are not everywhere, and even the appellate tribunals, for example, when they are supposed to have benches, don't. For example, the appellate tribunal for electricity is only functional in Delhi, and it has at least, like, all the litigators know that you have to wait for at least a year. The pendency is insufferable. So even in terms of geographical access to justice, your appellatory rights are severely compromised. And the NGT, of course, the questions of procedure have been addressed by Prashant, but it's not a good idea at all.
Yeah, and even NGT, there's no geographical access. Like, it's there only in some 4 cities. So before, every high court and some district courts would have jurisdiction over this stuff. They created NGT and they gave it jurisdiction only in 4 cities. So a city like Hyderabad doesn't have NGT bench. I don't even think Bangalore has. I think only, for example, Chennai, I think, has for the South zone. These are absolutely brainless ways to design tribunals.
And the benches where they are supposed to be benches don't have judges. Like, most of the NGT benches are vacant. I think only 2 are functioning, something like that. So yeah.
So I'm going to speak in one last question because this was a question I wanted to ask much earlier, but I forgot. Age. You write in the book that the age at which the CJM and probationary judges are being appointed after judicial exams has slipped down to 28, 29 now. It used to be much higher earlier, but the latest crop, I think the data you cite from 2023 is it being 28 and 29. So could we presume in 2032, it'll be around 25, 26, So what's happening with these judge mills that one sees advertisements for everywhere? And second, what are they trained in? Because they're not really trained in anything. And so you become a CJM, you start delivering justice, but you are not really confident in the nature of the law because the questions that are used for selecting you, they are mostly rote learning. I think there is only Delhi that you mentioned that has 40% of it being legal reasoning and then interview. So my question is, forget about all of that. That's procedural and not a lot that we can do in. But when you have a judge who's coming out from one of these coaching classes, and these coaching classes are always in the news for all the wrong reasons, right? Uh, Money that has been paid, classes not delivered, so on and so forth. Does it not start off your legal career on the bench with a sort of a compromise as to what you're supposed to do vis-a-vis delivering justice? Because these coaching classes are geographical now. They're all over the place. They're on internet. So, you could be, it's not like an IAS officer that you're given a different cadre. You are a judge, you're a CJM, etc. You could be hearing their cases. In fact, we've seen an instance of this recently in Bangalore, that infamous case of Devas in Bangalore, where they found some bodies, and it turns out that the judge who gave the order for taking down all the news stories was representing that same sort of trust. It happened in Karnataka recently. Devasthala, I think that's the name of the place.
Yeah, the religious trust.
Yeah.
There's some allegation of bias against the judge. But see, this issue of very young people becoming judges has become a very contentious issue. When I think it's a no-brainer at all. Like for example, we're talking about the median age being around 27, 28 years in some states, and it's fallen from 31 or 32. But there are people as young as 21 who have cracked judicial services examination, right? Because when we're saying median 27 in Madhya Pradesh, that there were 260 people who were appointed younger than 27 years. So there are some really young people. I mean, at 21, 22, your frontal lobe is not even developed completely, right? It takes till 25 for it to develop. And India is the only country where for some reason we celebrate this. Like, I mean, youth is fine when you're talking about, innovation or services like the army or the police services where physical fitness is a requirement. When it comes to the judicial office, it is people like me with white hair we want on the bench. Okay, I'm prematurely invited, but the average age of appointment in the US for the lowest tier of the federal judiciary, which is the federal magistrate, the law over there requires only 5 years of practice, but the actual years of practice of appointees is 20 years. 23 years. And the average age at appointment is 50 years. And in the US and UK, it's about similar for all tiers of the hierarchy, of the judicial hierarchy. That is, you will be around 50 when you're appointed to all these offices. In India, for some reason, we have just baked it into our mind that the fellow at the lowest level has to be younger than the fellow at the highest level. The Indian brain cannot comprehend a scenario where you can have guys at 45 years, 50 years at all tiers, from the Supreme Court to the lower judiciary. And the reason we have spoken, written so much about this even in the book, is because law is one of those professions where practice makes all the difference. It is not something that you can learn only in the book, especially in India, where there's such a wide gap between how laws are written and how they're practiced. So you need to have experience at the bar to understand how the law actually functions, how clients are dealing with issues, how do you deal with registry officials, what all is going on, and that is what makes you a good lawyer, right? So which is why the practice requirement is critical. I don't understand why we're all hell-bent on 3 years of a practice requirement. And you should see the difference, right? Even within the district judiciary, at a judicial magistrate level, you require only 3 years now after the Supreme Court judgment, which means people will be appointed by the time they're 30. They've had less than 7 years of practice. And writing that exam and also takes time. So presume they have only 5 years of practice. For the district court judge, the district judge, who is the top of the district judiciary, the constitution says 7 years practice requirement. But most states have drafted their recruitment rules to say that you need to be minimum of 35 years to be a district court judge. But the actual age of appointment for states where you could get data is 45 years, like in Madhya Pradesh and Karnataka. It's between 45 to 50 years. So why is it that for those tiers of the judiciary, you want more recruited, more experienced candidates, but for the judicial magistrate and the civil judge junior division, you're willing to get people who are in their 20s? It makes no sense, right? And these are people like the Bar Council came out with a press release a few years ago, which we cited in the book, which has said nasty things about these people. They're saying that they don't have any experience, they don't know what they're doing, etc., etc. It is very true. Because a lot of these kids are going to be, right now the profile is a lot of them graduate from national law universities and write this exam, without practicing law at all. So by the time they've sat as a judge on this bench, they've probably not even negotiated a rent agreement in a city. Which is, for a lot of urban Indians, that is one of your markers of adulthood, where you have to, first of all, find a house in a city that is not yours and try and negotiate a rent agreement. And that's where, they won't have even done that. And these guys are going to sit and decide life and liberty. And a lot of these candidates have been very vocal criticizing the Supreme Court about its judgment, saying that, oh, you're discriminating against us, etc., etc. But the judicial services are not about your personal ambitions, which is about delivering justice to people. Your personal ambitions are a distant second goal in the entire policy matrix, which a lot of these entitled brats don't understand. So this 3-year requirement also the Supreme Court has done is not enough. They should put a 10-year requirement minimum to join the judicial services. That's the end of my rant. Sakshi, do you want to add?
Yeah, the other absurdity is that a lot of these selection rules also limit the age of people to apply and write these exams. Like, for example, in Uttar Pradesh, there is an upper age limit of 35 years. I think in Delhi
Yeah.
it's 32 years. So it's not just that you are actively depriving people to become judges at a later age. And as Prashant mentioned, the other way to some of our other colleagues at the previous think tank had done a report called Breaking Through the Old Boys Club, where they had demonstrated how women are increasingly writing these entry level exams and getting recruited as judges in the civil judge and magistracy positions. But and then that's a good thing. But the problem is then you are really so you have sort of accepted that the bar is very hostile for women, and there is no effort to reform the composition of the bar or to make it friendlier or more familiar to women to practice law as a lawyer. And the only way they can enter the profession is through writing these exams, and then they write these exams, get through these judgeships, and that's the only way they become a part of the legal profession, not through the practice of law. I mean, of course there are more women coming in now than before, but the gender ratio is extremely skewed, and I would assume it is the case with the other marginalized identities as well, because the practice of law is still seen to be very, very nepotistic and network based than the actual judging part of it.
Right. Right. Thank you very much. I hope that this book is read, and I hope this book is translated into Hindi because, the states that you often really talk about, I think people of Bihar and Uttar Pradesh have a lot to say about delivering
No Hindi
justice. So I
publishers
really hope that
interested.
you.
We tried.
Oh,
We
really?
tried.
They're
We
not
tried pitching it
interested.
to a Hindi publisher. They just weren't interested.
Well, if you please let me know. I think I can swing Hindi publishers. I
Oh,
can
great.
make them do things.
We'll be in
So
touch with you.
please, if you want it, I would want it to be published in Hindi because it should. I think Shivani, over to you now. Thank you very much for your time on Saturday, and
Thank you so much for having us.
yeah, and it is a fascinating book, and may it scale the charts of best-selling lists uh, up and up. I hope it goes abroad as well, and because your publishers can do a good job of that.
Yeah, I
Shivani,
mean,
over to
if they
you for questions.
sell in India, it's enough.
Thank you, sir. Thank you, ma'am, for taking us deeper into the themes of the books. I'll just ask one question and then we have questions from the team. So, there's a chapter in the book titled Bring Back Jury. It suggests that juries could revive the judicial legitimacy, but given the concern that caste is a sensitive topic and already difficult to study, do you think that Dalit and scheduled tribes may not trust juries dominated by members of dominant castes or vice versa? And how do you see trust being built and their participation being genuinely meaningful?
Yeah,
Chitrashi,
I
why don't
can
you
take
take it?
that. Yeah, thanks, Prashant. The So clearly, we do know that the marginalized communities are overrepresented in the criminal justice system as under trials and accused. So the identity of the accused will play a role in deciding the composition of the jury. What we were, and of course, there should be representational safeguards for the composition of juries depending on the identity of the accused. We were more making a case normatively for the acceptance of juries as an institution for criminal trials. This will of course be designed very, every jury has to be, the composition can be tailored, and representational safeguards need to be there, especially in a society like India, which is extremely divided, and we know the marginalization that these identities go through in the criminal justice system. So those are very valid concerns in the operation of jury as an institution. We are making a principled case for why we think juries can in fact build more trust in the judiciary, in the courts, because when you participate as a juror in the decision making process, it can really empower you. It is very good for your civic culture, and given that we know we are going through a crisis of legitimacy with these courts as an institution, it can really embolden the participation of common people in the justice system in a manner that treats them as equals and not just as witnesses or litigants, and sort of, that might mitigate some of the hierarchy that is embedded into legal profession and courtrooms in the architecture in general. So our case is mostly a principal defense of juries. Of course, the operation and logistics will have to be tailored to suit the needs of the society in India. So those are valid concerns, and they can be addressed through designing rules which have these safeguards.
And just to add to what Chitrashi said, at the end of the day, even judges, there are a lot of allegations of casteism against professional judges all the time. Like there have been 2 impeachment motions in the last decade against High Court judges on the issue of caste. One is the current, Justice Patiwala, who's on the Supreme Court. When he was a judge of the Gujarat High Court, he made some comments against reservation. MPs moved an impeachment motion in Parliament against him, and then he amended his judgment and took those words out. There's also an impeachment motion against a Andhra High Court judge, Andhra or Telangana High Court judge, on the issue of casteism. That didn't proceed, but these allegations are there across the board. So rather than having one judge sitting on the bench, wielding allegations, facing allegations of casteism, you may as well create a pool of 12 people with, representation across caste lines. That may help, in fact, build confidence in the system.
Yeah, and because it's a collective institution, the chances of moderating the bias of individual jurors are higher than, for example, an individual judge who, of course, we know are prone to biases.
Thank you, ma'am. Thank you, sir. We have next question from Kushi. She says, thank you for such an interesting session, Reddy sir and Chitrakshi ma'am. Given the historical colonial origins of India's judicial appointment criteria, to what extent do you see the current reforms as a genuine break from the past rather than a cosmetic update? What would a true system reboot look like?
I mean, see, currently there are no reforms, right? It's just that you're saying that let's just put in more money and judges and things will improve, which has always been the case. We've not really broken from that. To a system reboot, in my opinion, would be to model the district judiciary as a judicial, as an independent judiciary, not an arm of the bureaucracy, which is how it is currently modeled from, back in colonial times. That is, these judges are joining, they are part of a judicial service, which is technically an arm of the state civil services, which is why all the state civil service rules are applying to them. I would envisage a district judiciary more on the lines of, say, the high courts, where each judge is considered to be as an individual, not part of this bureaucratic service, where they have solid safeguards against how disciplinary inquiries are conducted against them, how they can be transferred and promoted, etc. Do we really want to give them incentives such as transfers and promotions? Because whoever wields that power then also wields control over these judges. So the idea should be to break it away from this entire bureaucratic mindset of how we've organized the civil services, etc. That would be a system reboot, in my opinion. Chitrashi, you want to add?
Yeah, and making them more transparent in the administrative functioning through either laws made by the parliament, where they have some certain duties of disclosure about being more accountable in the way they administer these judges. So all these vigilance complaints, the process of these disciplinary inquiries, and even other bureaucratic procedures that are relevant to these judges should be conducted in a more transparent fashion.
Thank you. The next question we have is from Niti. She says that the book also suggests replacing written exams with a system focused on assessing candidates' legal experience through documentations and interviews. What risks do you perceive in moving away from a test based model to an experience based and interview driven appointment? Are there any risks that you perceive?
Yeah, I mean, in India, you're always going to face allegations of nepotism, etc. When you have, an interview-based system, uh, because there's always going to be a subjective element, and as a society, we seem to have infinite faith in written examinations. We think that is the ultimate test of objectivity and, uh, you know, destined to eliminate all kinds of nepotism. But in the present format, also, it is actually a mix of a written examination and an interview. Although the written examination has a higher component in this thing. The interview, if you fail the interview, they can still block you. So in that sense, currently the written examination just it operates as a filter for the interview process. But our complaint generally with the written examination is you should see the kind of questions they ask. It's testing rote, rote learning ability for most part. And a lot of times they'll ask obscure, questions which kind of fundamentally misunderstand what a lawyer is supposed to know. You will have great judges even in the Supreme Court who will not know these answers to these obscure questions. The the test should not be of your knowledge of these obscure areas of law. The focus should be on your ability to think through problems, critically analyze, and be able to write them. And the our bigger complaint with written examinations is it can't measure whether you are temperamentally suited to be a judge, right? You can be brilliant at cracking written exams, and you can be a complete psychopath on the bench. So an interview process will kind of test your temperament a little bit better, where you can figure out is this person suited for the job of a judge. And which is why we also say that you look at his practice requirement, right? If a lawyer has done well enough in court, or at least has a good reputation amongst the bar, you can be kind of certain that he's not going to be a complete psychopath. But otherwise, with this written examination, the focus being entirely on the written examination, it's especially for the entry level, it's the focus is more on the written than on the interview. You can get really horrible candidates on the bench.
And since we're also advocating for a longer practice requirement to be eligible for these things, you will also have records, like in the sense in the cases that you have represented, which can be used to assess your drafting, pleadings, etc. So legal skills can be tested through many other ways. We have just decided to make sure that only rote memorization is a skill that we want to cultivate.
So just coming back to the question of risk, what risks do we see when something like this is happening? The traditional complaint with these interview-based systems is the nepotism, and that's a valid concern. The way to do this in a manner that negates these concerns is to do it transparently, right? So there's no reason why an interview process of a judge should not be televised, or at least maintain a written like a record of the entire interview so that people can access it later. Like public hearings for confirmation proceedings in the US and all are public. There's no reason why it shouldn't be done in India. The moment you start doing a lot of this in the public eye, you will start building up confidence. The reason Indians, I suspect, have such low confidence in interview-based selection mechanisms is because it's conducted behind closed doors and you don't know what is happening. And the test should be, like these IAS civil service exams asking some crazy like gimmicky type of questions. The focus should just be to evaluate what kind of person you are and what is your temperament. Otherwise, your practice record as a lawyer should be what speaks for your experience in the legal profession and your knowledge of the law.
Thank you. We have already taken a lot of your time, but we still have one last question. It's from Bhupesh. Will adding more judges solve India's justice crisis, or do we need bold reforms in procedures and accountability? We have already spoken about the reforms and the procedures. So, if you could just answer, will adding more judges solve India's justice crisis?
I don't think it's going to change much. Little bit, there may be a marginal improvement, but we don't see the increase in judges significantly changing outcomes because, like we mentioned in the book, right? In 1987, India had about 7,500 judges. By 2025, we have about 21,000 judges with about 4,000 vacancies. So the judge strength has tripled, and judicial capacity has increased because we've created debt recovery tribunals, etc. So a lot of cases that used to be heard by the district courts is now shifted to these tribunals. But yet the district courts continue to be astoundingly dysfunctional. Things have not improved in any measure. Like, you don't need statistics to know that. There's enough anecdotal evidence to show that it's not working. So, which is why, our book is a plea to move away from this resource crunch argument to one which looks at other issues which are affecting efficiency of the judiciary, which includes disciplinary proceedings, the performance assessment system, transfers. These are all disrupting judicial efficiency, which is what we think where most of the attention needs to be focused on now.
Thank you. So, do you have anything, or should we close the session?
But yes, thank you very much for your time today. And we'll be putting it up online, and hopefully some more people see it. And we hope to have you back soon.
Yeah, thank you so much for having
Thank
us.
you so much for having us.
And for reading our book twice.
Yeah.
Well, the second time I had to read it for the conversation. But it was a fun book. Thank you very much.
Thank you.
Thank you so much.